Yeah, so today, Chris, we're talking about amputation medical malpractice. What are some of the most common scenarios that lead to medical malpractice lawsuits involving amputation?
Well, most amputations are a result of a loss of blood flow to a limb, mostly the leg. Those are the most common amputations. And the way you would have a loss of blood flow is either, one is you're not getting enough blood flow because your heart's not strong enough to pump blood, to all your extremities, or you get some kind of blockage in a artery that takes blood to that part of the body. So a lot of people are prone to it, because they have, heart issues, or they have hardening of the arteries. It's not always just the coronary arteries. You can have that in your legs. That's pretty common. It's called peripheral artery disease. So if you have that, you can get blockages, and if that's not detected soon enough, there's lots of tests that they can use to determine if you have adequate blood flow to your feet and to your lower legs. And if for some reason you have the symptoms and the doctors don't follow up on that or don't do the proper tests or they misread the tests, that can cause you to go for a period of time with either not enough blood flow or no blood flow. And eventually, all your tissues in your body need blood to get oxygen. Without oxygen, your tissues and muscles start to die. So the longer that goes on, that can lead to death of the tissues in that limb, and to the point where they would need to amputate the limb, because once it starts dying, it starts causing infection and can lead to other problems.
So we're not talking about here what might be some people's a nightmare scenario, which would be like maybe they have to have a limb amputated, but they go into the hospital and actually the other limb is accidentally amputated or something like that. Now they have to have both of their limbs amputated. We're not talking about mistaking the left leg from the right leg or something like that.
Well, I mean, that's wrong site surgery. I mean, that does happen. Uh, but I mean, in that case, the negligence, there is negligence. Normally, if somebody needs to have their limb amputated, it's preventable. Unless you get like in a car accident and you have some kind of crush injury or something that cuts out blood flow to that limb. But even in those scenarios, you can restore blood flow to the limb if you get it quickly enough. But so yeah, normally, if you get to the part where somebody does need an amputation, obviously identifying the right, leg or arm that you're going to amputate is critical, but that's a whole nother topic.
Yeah. So in terms of this topic here, for a layperson listening, can you explain what maybe the legal standards are for proving medical malpractice in an amputation case like this that we're talking about?
Sure. Well, I mean, the important thing to remember is there's no malpractice isn't really a legal standard. That's kind of a common term. In Ohio, the cases are referred to as medical claims under the law. So a medical claim is anytime you bring in a case against a doctor, a hospital, a nurse, whatever, any kind of medical provider, uh, claiming that their negligence has caused injury. So the three things that you need to prove in a medical negligence case is, first of all, negligence. And negligence is defined in the law as either failing to do what a reasonably careful provider would do in the same or similar circumstances, or doing something that a reasonably careful provider would refrain from doing in those circumstances. So basically, it's a failure to act as a reasonably careful doctor, nurse, whatever the negligent person, whatever their title is, failing to do what a reasonably careful person would do in those same circumstances. Um, and once you prove that, that's the negligent part, then you have to prove that negligence caused an injury. That's what's known as proximate cause. That means if they, hadn't done what they were supposed to do, this wouldn't have happened. Basically, that it's preventable. And then the third thing you need to prove is what is the extent of the harms and losses that were caused by the negligence.
And so, what type of evidence is typically needed to build a strong case, in a medical case like this?
There's basically three types of evidence that are used. So one is the medical records. The records, document or should document what actually happened or what the caregivers, were doing or what they were thinking at the time. The other thing in a case is, radiographic images, if there are any, are particularly important. So, you can show a jury, through a CT scan where the blockages are, what the doctor should have seen, why was there a loss of blood flow to this particular limb that requires amputation. All medical malpractice cases need to be proved through expert witnesses, meaning each side has to have doctors that they retain that are supposed to be experts in the field to talk about what should have happened, why the injury was preventable, and what the extent of the harms and losses are as a result of the negligence.
How do you go about getting, and collecting that evidence? Are there laws that allow you to just, see those records from the hospital and things like that in this type of case?
Yeah, absolutely. There's a federal law, and I think people know or have heard of HIPAA, which is just, the acronym for the name of the statute. And people think of that in terms of, well, you can't talk about, other people's medical care, but it's actually a lot more than that. And HIPAA, that particular law, which applies, across the entire country, requires healthcare providers like hospitals, doctors' offices, anybody that, first of all, they're all required to keep medical records anytime they give medical care, provide medical care. And the other thing is they're required to retain the medical records for 10 years. And any patient is allowed to request the medical records. And under the HIPAA law, they're entitled to see the medical records. The providers have to provide the records within 30 days of any request for those medical records. But yeah, the short answer to your question is every patient's entitled to a copy of their medical records.
And so, what are some of the key challenges maybe that plaintiffs might face in these types of amputation cases?
Well, as long as we're on the topic of medical records, the key challenge is just getting the medical records in the first place. Because despite what I just said about there being a law, healthcare providers are pretty reluctant to turn over medical records. When there's, if a patient requests their medical records, they're never going to get the whole set of medical records, which is a reason why you need an experienced, lawyer who's, handles medical malpractice case. Because number one, they know what a complete set of records looks like. They know what to ask for. And two, they know when they haven't gotten what they're supposed to get. And so,
right. Hey, we're missing, we only got A, B, and C. We're missing X, Y, and Z.
Right, exactly.
Yeah.
So it requires a lot of follow-up, and we have people at our firm that's their job, to request medical records and then follow up once we don't have what we're supposed to get. And then the other biggest thing is going to be that, as I said, most people that are prone to having medical issues that could lead to amputation, have some kind of underlying medical issues, like, people with diabetes tend to have poor circulation, in their extremities. So they're prone to these types of issues, and, infections in their feet. Or the person may have some kind of, underlying problem with the heart, which causes that blood not to circulate. And so generally the defense will try to use those underlying medical conditions against the person and say, okay, well, it's not our fault. It's the patient's fault for having these conditions in the first place or not taking care of themselves.